Okay, welcome everyone to the Judiciary Committee hearing this Tuesday morning at 9:45. We have a couple of agendas. We'll start with the 9:45 first. We do have a 2-minute time limit on testimony, both on Zoom and in person. And if we have a catastrophic failure on the Zoom side, we'll go ahead and try again tomorrow in this room. So that would be Wednesday, March 19 at 9:30 in this room 016. Hopefully that won't happen. First up today is HB House Bill 126. This is having to do with civil asset forfeiture. First up on HB 126 is Attorney General's office in opposition. Good morning.
Morning, Chair Rhodes, members of the committee. My name is Gurudev Allen. I'm a Deputy Attorney General. I'm here on behalf of the department to testify on our position. I won't belabor the points in our written testimony. As we said in our written testimony, we do strongly oppose the proposed SD1. We did not oppose HD1. This proposed SD1 substantially changes the bill into more like what SB 722 was. And our concern is that some of these provisions, particularly the requirement of felony conviction of the owner and changes to the asset distribution, would undermine the program to the point of practically ending it. So we believe this would have negative fiscal consequences and law enforcement consequences. We believe that civil asset forfeiture is a useful law enforcement tool and that there are sufficient safeguards in place to protect owner rights. I'm available for questions.
Good, thank you. Next up is Haley Chang for Office of Public Defender. Good morning.
Good morning, Chair Rhodes. On behalf of the Office of the Public Defender, we absolutely support this measure in addition to the proposed SD1. As indicated in our written testimony, criminal forfeiture, I believe, or civil forfeitures across the nation, the trend is to move away from them because of the problematic aspects of this process. We inherently believe that there is a tension or a conflict when law enforcement is incentivized to seize property, especially when that seizure does not have to result in any conviction whatsoever. I don't believe the general public knows the burdens of trying to retrieve your property back if it is subject to forfeiture, and the provisions proposed by SD1 would further put limits on this process and move towards the national trends of moving away from civil asset forfeiture. So we will be available for any questions. Thank you for the opportunity to comment.
Thank you. Next up is Domingo Manog for Honolulu Police Department. Sorry, I can't tell your rank, so.
That's right, Chair. Good morning, Chair Rhodes.
Major or captain?
Acting captain.
Acting captain. All right, please proceed. Good morning.
Good morning, sir. Anyways, yeah, my name is Domingo Manog, acting captain of the Narcotics Vice Division of the Honolulu Police Department, City and County of Honolulu. The Honolulu Police Department opposes House Bill 126, House Draft 1, proposed Senate Draft 1 relating to property forfeiture. Asset forfeiture is an essential tool for us law enforcement community uses to take profit out of crime. It has also served as a deterrent against future illegal activity involving forfeited assets. Proposed changes by this legislation would significantly compromise and affect law enforcement's ability to combat those who profit from illegal activity that victimizes our community. Delaying or eliminating the local investigating law enforcement agency from the proceeds of property forfeited from illegal activities will directly impact our ability to serve our community. Thank you, sir, for the
Thank you very much. Rebecca Leakey, prosecuting attorney for the County of Kauai in opposition. Maui Prosecutor's Office also in opposition. Darnella Villanueva for Honolulu Police Department in opposition. Daniel Hugo. Yes, you're here. Good morning.
Good morning, Chair Rhodes and Senator Sam Buenaventura. The department did support the House draft of this bill. However, we cannot support this one. And the reason is because of the specific provision that requires a criminal conviction for property forfeiture. And we point to at least 3 problems that could occur in our written testimony. The first being that the individual may die during a pending prosecution, as happened with Mr. Miskie's case. Second, that this may encourage individuals to flee from the jurisdiction, in which case you can't convict them, but they will still have access to the proceeds of criminal activity. And then finally, sometimes we cannot identify who the owner is, even though it's clear that those proceeds come from criminal activity. And we give the example of gambling currency that's left behind a murder scene. I'm available for questions. Thank you.
Thank you. Next up is Kat Brady for Community Alliance on Prisons. Good morning.
Good morning, Chair Rhodes, Senator San Buenaventura. Kat Brady testifying in strong support of this measure for Community Alliance on Prisons. This bill really increases transparency and accountability. And right now, according to the AG's 2018 audit, there wasn't a heck of a lot. So we really believe. it's
Sorry to interrupt. Can you
important.
just pull the mic down to you? Thank you.
We believe it's really important. It authorizes also that after expenses, the funds go back to the general fund, and we really appreciate that. I know several years ago, when Susan was the police chief, they bought a $150,000 robot dog. So I wonder if that came from the proceeds of forfeiture. And forfeiture has been discussed at the federal level. There's bipartisan support for it. And we just think it's about time that we stop criminalizing people. Thank you.
Thank you. Next up is Ted Kafalis for Grassroots Institute of Hawaii. In support, next is Nikos Leverance for Drug Policy Forum of Hawaii. Good morning.
Good morning, Chair Rhodes, Chair San Buenaventura. My name is Nikos Leverance on behalf of Drug Policy Forum of Hawaii, and we stand in strong support of the proposed SD1. We also supported the prior bill, and in fact, the prior bill showed that there were significant reservations among some in the criminal legal community just about increased accountability and transparency efforts. So, in conjunction with what the state auditor found in 2018, a system that lacked accountability, that lacked transparency, where proceeds were given to salaries. We need to end this system which turns the law on its head, where innocent people are proven guilty. As noted by Mr. Brad Cates in his Washington Post editorial, there are valid time-tested methods to exist to allow law enforcement to seize contraband profits and instrumentalities via legitimate prosecution. So let's stand for property rights. Let's stand for individual rights at a time when the executive authorities are seeking to, to overstep boundaries hither and yon. So mahalo for introducing this SD1, and we stand in strong support.
Thank you. Next up is Frank Schultz in support. Michael Older on Zoom.
Not available on Zoom, Chair.
Also in support, Carla Allison in support. Thaddeus Pham in support. That's everybody who signed up on HB 126. Would anyone else like to testify on HB 126? Seeing none, Senator, any questions?
Yeah, prosecutor. So I was the introducer of the original long time ago, 10 years ago, property forfeiture program. I mean, civil asset property forfeiture reform. And at that time I settled for an audit. And at that time, the audit showed that basically the rules were not being followed, that the proceeds from the forfeiture were supposed to go towards like substance abuse, and none of those monies actually went there. Do you have an accounting of where the monies are going now?
Well, at least within our office, Department of the Prosecuting Attorney's Office, the deputy who works on that is a member of the Career Criminal Division. So these are not proceeds that are coming to us. But what I can say is that, as we emphasize in testimony before the Finance Committee, we don't oppose accountability or transparency.
Okay.
We're fine with that. It's the criminal conviction provision that we think will specifically be a problem.
So, and I understand that too. And the other reason that I had introduced it before was because I represent a place in the state of Hawaii where there's a high amount of, where the population base has a very low standard of living, and they are victimized more proportionally than the rest of the population regarding civil asset forfeiture. So has there been a study as to the equality, as to how you folks assess the property forfeiture? Because my concern at that time, and I had given multiple examples because it was a time when I was still practicing law, was that there was a disproportionate amount of low-income people having their cars, their generators, the only source of transportation being taken just because like one person in the family may have been arrested for a crime, whereas that vehicle is being used by other members of the family because they're poor. Has there been a study as to the equality of how you folks assess the property forfeiture?
So I'm not aware of any specific studies, but I think that gets to the nexus between the property and the crime. And, you know, if the legislature wants to consider maybe a higher burden of proof threshold or increasing the rights of co-owners to be able to assert their rights, we don't have a problem with any of that. In the cases that I'm aware of, we can show beyond reasonable doubt that the property is attached to proceeds of criminal activity. So higher burdens of proof, more rights for co-owners, those are not the issues. The specific concern that we have is the ability of organized criminals to structure and evade property forfeiture proceedings and continue their criminal activities.
Okay, so I'm sorry, one last question. And the reason why I'm insistent on the conviction is because in the criminal conviction, criminal defendants have a right to an attorney. Whereas in a civil asset forfeiture, that's the reason why disproportionately poor people end up getting their assets forfeited, is because they cannot afford an attorney. What is your position regarding giving rights of counsel to individuals whose assets are being forfeited? Would a prosecutor be willing to use their budget in paying for such attorneys?
Well, I can't speak for this specific budget, but at least the principle of them being represented, we would not have an objection to. And in fact, in some cases, it would make it easier if we could deal with a lawyer.
Okay, thank you very much.
Before you go away, so the fundamental crux of the problem for the disagreement between me and most of the law enforcement community is that you guys, you're just said that the problem is that you have to have a criminal conviction. I would say that's exactly backwards and 180 degrees wrong. Why should you get penalized for anything until you've actually been convicted?
So asset forfeiture is a proceeding that is often used against organized crime. And so just to give a simple example, if you are trying to prosecute an enterprise and you prosecute one member.
I understand how the process works, but what you're saying is you can punish people before they've been convicted of anything.
So the attempt is to stop the enterprise from continuing its criminal activity.
The bill allows for that. It allows for the seizure, just not the forfeiture.
So respectfully, it doesn't, because if that person, the person who's being prosecuted, transfers their proceeds to another member of the enterprise who's not currently being prosecuted, that enterprise will continue. And that's been that is one of the reasons why we've had asset forfeiture in the first place. It's to attempt
But you can still, under the language of this bill, you can still seize it.
So
you just can't sell it.
So if it's
it just feels like it's complete. The whole criminal system is just flipped on its head. You can punish people. It's like putting people in jail before they have been convicted of anything, and even if they're not a danger to the community. It's just flipped on its head. Why do you guys support this?
Well, again, So that specific example of transfer, you might be able to address it by having a seizure, but it still doesn't address other issues that we've talked about, like if the property is clearly the proceeds of criminal activity, but we can't identify who the criminal is.
Well, then is somebody claiming it? I mean, who comes and claims it? If it's
Right.
part of,
So common example, and this is the one that I gave before the finance committee, is that the police raid or they go to a gambling scene, illegal gambling house after a murder.
right?
They put out a notice
So
to
what
claim these.
happens so if you don't seize it, I mean, you are going to seize it. I mean, you're going to take it. You're not going to just let it sit there. But the police department takes it. No one claims it. So then what happens to it?
It stays in storage.
Forever? It doesn't escheat to the state?
There's nobody who's claiming it. We do have
There's rules about when eventually, if no one claims property, something happens to it.
Well, I'm aware of at least one forfeiture proceeding where we're undertaking precisely because it's a large vehicle that was used in a crime that is just sitting there and occupying space that the police need. And so we are trying to go through this forfeiture proceeding so that they can move it out of that space. Otherwise, it's just going to sit there.
So, I disagree with that statement because I
Go-
can give
go
you,
ahead.
I
Go
can
ahead.
give you a prime example as to one of the reasons. I mean, client's property was taken. They did not even attempt to prosecute, but because the policeman did not know who to believe as to who owns the property, and there wasn't even a crime accused, they end up storing it just in case they could use it for evidence. And 5 years later, they decide to auction it off. And it was only at that time that my client said, wait a second. I mean, I've been trying to get the police to return my property, and it's only because they end up hiring an attorney. And most people can't afford an attorney, that they end up getting their property back. And that's the whole problem with this. I mean, so I severely disagree with your claim that it just sits there, because the reality is it's going to be auctioned off because the police don't have the storage to keep these things up. And what happens is then assets are going to be gone forever. The people whose crimes or who is alleged to have committed a crime, and in this case, my client wasn't even accused of being a criminal, except that the asset was the policeman. I guess he was a rookie, didn't know what to do with the asset when there was pilikia in a divorce proceeding, decided to just grab it. What happens to those properties? I mean, that's a problem I have with this. It requires people who already own the stuff to have to prove and hire an attorney to acquire it back from the police, because they use their police powers to grab things that were not theirs. I mean, we cannot put a theft claim against a policeman who just grabbed the property, or can we? Are you going to give give public citizens the right to file a police complaint for theft for property that was acquired and for which there was no criminal complaint ever lodged?
So Senator San Buenaventura, that case illustrates a prime example of why I said, at least in principle, we would not oppose having people in forfeiture proceedings represented by a lawyer. Because if it is easier usually to work through a lawyer, and what a legitimate property owner whose property is seized by the police would do is have an interpleader action in which they would go to court counsel and be able to recover their property. My guess is that because this person did not understand the legal process, they weren't able to undertake a legitimate avenue. Once they had an attorney, they were able to do so.
Okay, thank you.
Thank
Thanks very much. We'll go ahead and move on to the next. Go ahead and move on to the next bill, HB 280, relating to community outreach court. Permanently establishes and appropriates funds for the community outreach court as a division of the district court of the First Circuit, which is Oahu. First up on 280 is Deputy Attorney General Mark Tom on Zoom. Oh, in person. Good morning.
Good morning, Chair, Senator Sam Buenaventura, Deputy Attorney General Mark Tom for the department. Department provides comments and suggested amendments for House Bill 280 HD1. First, the department would just want to point out the amazing work that the agencies have done thus far with Community Outreach Court. When I was a prosecutor, I was assigned to this court. I was there when it was an unfunded court in district court, to Act 55 when it was funded through COVID, as well as the expansion into a number of locations within the community. So it seems counterintuitive in our testimony of the amendments, the two amendments, which is to remove the attorney generals from the definition in Section 2 and to remove the funding mechanism in Section 7 for the attorney generals. I will note to the committee that the attorney generals works very closely with the three agencies, and this amendments is more to ensure efficiency and streamlined effects of this courtroom, which is very important for this target population. And so with these amendments, we are still, the attorney general still sits with the stakeholder meeting and makes sure that there are no any cases that are state initiated are still qualified for community outreach court and not lost through the cracks. So I will be here for any questions. Thank you.
Thank you. Next up is Thomas Haya for the judiciary. Or Ms. Designee. Good morning.
Antina Nova'a, Section Administrator for the Specialized Program Services Section, which includes the Community Outreach Court. Now, since its inception in 2017, Community Outreach Court has provided individuals with the opportunity to resolve their legal challenges, access critical services, and make real progress towards achieving stability. By clearing cases, lifting driver's license stoppers, and recalling bench warrants, COC has helped hundreds of participants improve their access to employment, housing, transportation, and essential documents like Social Security cards and birth certificates, ultimately improving their well-being. The success of Community Outreach Court demonstrates the importance of this specialized court in addressing the needs of this vulnerable population. Making Community Outreach Court permanent will ensure continued support for those working toward a second chance. We strongly urge the passage of this bill to ensure that Community Outreach Court continues to be a vital resource for those in need. I'm happy to answer any questions. Thank you for.
Thank you very much. Next is Haley Chang from Office of Public Defender. Morning again.
Good morning again, Haley Chang, First Deputy of the Office of the Public Defender. We stand in support of this measure to make Community Outreach Court a permanent part of District Court. We represent all of the clients in the program thus far through the years, and we have seen the impact and the difference that it has made to those clients and their lives. Also, the unique function of going out into the community and reaching people who otherwise have financial or transportation burdens that make it very challenging for them to come into the normal court system has been exceptionally positive, and we have been able to reach countless individuals. I do just want to briefly comment on the Attorney General's proposed amendments. This issue has been fleshed out, I believe, without speaking for the other agencies amongst the public defenders, the prosecutors, and the attorney generals. And with our understanding of the continued role that the AGs will play in the movement and the success of the outreach court, we don't have an opposition to striking them from the language of the bill as they have requested. Again, that has been done, that decision has been made after dialogue with the agencies about ensuring that this will not prohibit or limit the amount of people who will be eligible for COC, even if there are charges that arise from the Attorney General's office. So I will remain available for any questions. Thank you for the opportunity to comment.
Thank you very much. Next is Director Yamani for the Department of Human Services and support Hawaii State Council on Mental Health. And support McKenna Woodward for the Office of Hawaiian Affairs, and support Alan Johnson for HSAC Hawaii Substance Abuse Coalition, and support Heather Lusk, Hawaii Health and Harm Reduction Center, and support Jillian Anderson, Waikiki Neighborhood Board, and support Melissa Pavlicek for Opportunity for Youth Action Hawaii. Support Nikos Leverance for Hawaii Health and Harm Reduction Center. Good morning again.
Aloha, Chair, Vice Chair, members, Nikos Leverance with Hawaii Health and Harm Reduction Center. I apologize for the multiple testimonies, but we had the privilege of hosting Community Outreach Court, and I I concur with everything that of the prior testimony, and in terms of the impact that it's had on, people who may be facing housing instability or some behavioral health issues. And I want to underscore the importance of having community outreach courts in the community, including in venues like ours where, people come and avail themselves of services. So mahalo for the opportunity to provide testimony today.
Thank you. Next is Frank Schultz in support, Linda Rich in support, Denise Boycefort in support, Kim Jorgensen in support. And that's everyone who signed up on HB 280. Would anyone else like to testify on HB 280? Seeing none. Senator San Buenaventura, any questions?
No.
Okay, we'll go ahead and move on to HB 370. This increases the amount of partial public campaign financing available for all elective offices. First up on 370 is Kristen Izuma-Nitao, Executive Director for Campaign Spending Commission. Good morning.
Morning, Chair, Senator San Buenaventura, Kristen Izumi-Nitao, Campaign Spending Commission. We are here in support of the original version of the bill. Respectfully, the commission submitted our bill, the original bill, as our attempt to boost an existing program that's mandated by the state constitution, which has not changed, and whose maximum dollar amounts have not changed since 1995. With respect, we do have a couple suggested amendments in section 2 on page 2 to 3. As you can see, there are, they blanked out the percentage amounts. So we would ask that you set forth the percentage amounts in our original bill of 15%, 22.5%, and 10%, because in our opinion, those are good numbers that we could run a viable and enhanced partial public funding money with the 2.2 million that's currently in the trust fund. Further, we would recommend a suggested amendment on section 6, which would be to reinsert the $200,000 request appropriation and 2 full-time employees to equip the commission with additional staffing. We would just also comment that we understand that there's another bill, Senate Bill 345, that well, in its original form had a big difference with this bill, and we would just urge the legislature to pass something that will enhance the public financing program. But of course, we're here to answer any questions, because I know there's a lot of different formulas and suggested approaches, but we are on the same page with the shared interest in boosting the program. So
Okay.
thank you.
Thanks very much. Next is Beppy Shapiro for League of Women Voters of Hawaii. In support, Andrew Crossland, Hawaii Patriot Republicans. In opposition, Bronson Silva for Democratic Party of Hawaii. In support, Ann Frederick, Hawaii Alliance for Progressive Action. Good morning.
Aloha, Chair Rhodes and Senator San Buenaventura. My name is Aria Juliet Castillo. I'm here representing Hawaii Alliance for Progressive Action. We express our strong support for HB 370, along with all initiatives to increase the partial public funding financing for our state. It's crucial to note that our state public financing system has remained unchanged for the past 30 years, while the value of the dollar has more than doubled due to inflation. Our current political financing model is inadequate for today's political landscape. While there have been a few successful candidates who are utilizing the public financing program, these instances are not the norm, and most successes have been seen in the county level. In 2024, out of 25 candidates who initially signed up for matching funds, only 10 ended up using the program. That included 6 candidates for county council, 2 for OHA, and then just 2 for the state house. Clearly, we are doing something wrong and we can do something better. We urge you to consider amending HB 370 to align with the funding amounts that were allocated in the original version of SB 345, which this committee has already passed. By increasing the funding limits and raising the expenditure caps will make the partial public funding program a genuinely viable option for candidates across the state. A very important aspect of this bill proposes allocation for 2 additional full-time positions at Campaign Spending Commission. The staffing is essential, especially considering that the commission has not had additional personnel added in almost 30 years. Please commit to fully funding the CSC. Thank you for your support, and hopefully we can add on these key amendments and respond to the growing public demand for a more equitable and transparent electoral system.
Thank you very much. Next up is Evan Weber for our Hawai'i. In support. Okay, there's a long list of individual testifiers, most of which are in support. Okay. So anyone at this point, anyone else who'd like to testify on HB 370 on Zoom or in person? Okay, seeing none, the total statistics were 30 in support, 2 opposed, and 1 comment. Members, questions?
Sorry.
Okay, we'll go ahead and move on. Thank you very much for being here on that one. Next is HB 371, also relating to campaign contributions, prohibits state or county grantees and officers and immediate family members of state or county contractors or grantees from contributing to candidate or non-candidate non-candidate committees, candidates, or any other person for any political person for the duration of the contract. First up on 371 is Bonnie Kahakui for the State Procurement Office on Zoom. Good morning.
Good morning, Chair, member of the committee, Bonnie Kahakui, Administrator, State Procurement Office. The State Procurement Office stands on its written comments expressing concerns about the applicability and the requirement for state and county agencies to provide the information for all contracts, regardless of the dollar value. And we are available for questions. Thank you.
Thank you very much. Next is Kristen Izumi Natal, Executive Director, Campaign Spending Commission. Morning again.
Good morning, Chair. Thank you again. Kristen Izumi Natal, Campaign Spending Commission. This is an important bill for us, a very important bill for us. It's our attempt to address the pay-to-play problem that we hear a lot of public sentiment. It would extend the ban on contributions in state and county contractors to the officers of the contractor and their immediate family. It would also extend it to grantees of the state and of the counties via their county charter or code, and the officers of the grantee and their immediate family members. We believe that to get around the ban, government contractors and have persons connected to them make political contributions, thereby amounting to a violation of false name contributions where they were then reimbursed. So this is an attempt to address this, and we believe it also extends to the county contracts as well as the county grants and aid. It also requires that the state and county agencies report to the commission the names of their contractors and grantees, their officers and immediate family members. We are in discussion with and working with the State Procurement Office and the Department of the Attorney General in developing the mechanics for this to occur, because we can appreciate that there are notice requirements, that there is resource issues, but we do believe it's important, and I've already started discussions so that this could be something that's successful if passed. But we ask respectfully that you pass this measure and are available if you have any questions.
Thank you very much. Next is Beppy Shapiro for the League of Women Voters of Hawaii. In support, Laurel Breyer for Kauai Women's Caucus in support, and Frederick, Hawaii Alliance for Progressive Action. Morning again.
Good morning, aloha. Aria Juliet Castillo. I am here representing Hawai'i Alliance for Progressive Action. We are in strong support of HB 371. This bill is important because it aims to close the pay-to-pay loophole by stopping state and county contractors from making political contributions. This legislation fits in our larger goal of promoting ethical governance. It helps clear up conflicts of interest and make sure that elected officials are accountable to the people they serve, not just the donors looking to benefit themselves. Requiring the contractors to report their contribution, as this bill suggests, will make our procurement process much more transparent. Thank you.
Thank you very much. Next up is a number of individuals in support. So at this point, I'll just open it up. Anyone else wish to testify on HB 371? 371. Okay, seeing none, 29 in support, 0 opposed, 1 comment. Members, any questions?
Yeah, for
Fire away.
Kirsten. Thank you, Kirsten.
Yeah.
Come on up. So I noticed there's no Attorney General opinion on this. My main concern is First Amendment rights of that of a family member, because I mean, like, for instance, my family. My husband used to always vote against everything I would vote for. I mean, so you're telling him he cannot, which I'm okay with. I don't want him to go contribute to my opposition, but for a while there, we would cancel each other's votes. So what about his First Amendment rights?
Understood. And I can fully appreciate that. And in fact, we are in discussion with our attorney generals. And I definitely know that Bonnie Kahakui and I had a discussion, and she fully will be working with her attorney general as well. I think there's a way we can do this. In other words, if a contractor or grantee gets their grant and aid or a state contract, they do already have to provide information. And I think there's a place that they can provide their immediate family members. And I think we have to work around that. I believe, again, the mechanics have to be worked out, and certainly with that in mind. But let me just throw out, I was just throwing out there that perhaps that information could be embargoed until they get the award. But the idea is that we have limited resources. I fully appreciate state procurement's position about the resources, how intensive they are, but we've been able to do the contractor ban, the state contractor ban. There is a provision in all state contracts that the Attorney General has in their general terms and conditions, which is that if you get an award, a state contract, you are prohibited from making political contributions during the lifespan of the contract. I think we can add another sentence in there that would say you'd also have to disclose who your officers are and their immediate family members. And I think we can put that on our website in a place that can respect that. But of course, I understand that we'd have to work that out.
Yeah, no, I understand the officers part, because as an entity, but I have problems with the immediate family, especially, like I said, I mean, I'm not the only one. I mean, there's a number of family members. That's why it's always lively in Thanksgiving, right?
Sure. I think this was designed because we heard a lot as a result of the Dennis Mitsunaga's Keith Kaneshiro trial. And of course, you know, it was not a campaign spending issue. It was a bribery case. So I'll be very clear, but I think there was enough testimony that you could easily see what was happening. And this is exactly this measure is designed so that you don't have a state contractor and immediate officers with immediate family members making political contributions only during the life of the contract or grant. So it's not like forever. It's only during that span of time. So I think it's still an important bill. We've heard a lot of public comment on it, and this is our attempt to address it, to sort of close the gap on pay to play, which is perfectly fine, you know, given what our law says. But this one will close the gap a bit. And I believe that we would like the opportunity to work with the Attorney General's office. And I'm sorry, we've been in communication with them about this, particularly with the state contract, because I believe that is a place that we can provide some notice. And then I'm working with the state procurement office, and I realize there's other offices and entities that we'd have to work with. But I think it's important enough that we would try to, and to, you know, to get this off the ground.
Is this or do other states do the same thing?
Yes, there are other states that do this. As far as the mechanics of how the
Well, I'm not
notification.
worried about the mechanics. I'm worried about the constitutional part of it. So if other states have been doing the same thing for years, then I'm not very worried about the.
Sure, I can understand.
But I guess the answer to the question is yes, there are other states that do it, or no, there aren't.
I believe there are, but I'm not confident in citing to that right now, but I'm happy to go do the research and get back to you on that for
All right,
sure.
Thank you. Other questions?
No, that's it.
Nope, thank you.
Thank
Thanks very
you.
much. We'll go ahead and move on to the next bill. HB 413, this is clarifies administrative oversight of statutory restrictions related to prohibited lobbying contributions, clarifies that the regular or special sessions in which lobbyist contributions are prohibited are periods during which both houses of the legislature are in session. First up is Campaign Spending Commission. Hello again.
Hello again. All right, so we support this measure. Act 128 Session Laws of 2023 enacted a ban on lobbyist contributions to elected officials and other candidates during a legislative session. This measure really just seeks to clarify administrative oversight of that. So I believe it also clarifies what legislative session means, and that is both houses, so that there's nothing less left for interpretation. So we request that the committee pass this measure and are available for questions. Thank you.
Next is Frank Schultz in support. That's everybody who signed up on HB 413. Would anyone else like to testify on HB 413? Seeing none, members, questions? Okay, we'll go ahead and move on to the next bill then, which is HB 892. This establishes limitations on geographical restrictions provided as a condition of probation. First up on 892 is the judiciary. Saifulloy Agnanon. I'm sure I butchered your name. I apologize in advance. Good morning.
Good morning. Aloha, Chair and the committee. My name is Saifulloy Agnanon, and I'm the probation administrator for the First Circuit. We stand on our written testimony and support the recent amendments that further define the geographical restrictions and consider the ability for the individual to access individual and cultural practices to the extent allowable by law. Thank you for the opportunity to testify. I'll be available for any questions.
Terrific. Thank you. Next up is Sonny Gannon for the Office of Public Defender. Good morning.
Good morning, Chair. Senators, my name is Sonny Gannon. I'm Deputy Public Defender. The Office of the Public Defender usually doesn't have a sort of package. We don't introduce bills when we think that a client's individual rights have been aggrieved. We follow the ordinary process and we appeal. We think that this is such a violation of law and the morals of our community that we actually drafted this bill. Geographic restrictions have been in place for over 2 decades. Usually by the Office of the Prosecutor here in Honolulu under their Weed and Seed program, where they have enhanced prosecution and they ask for individuals to be separated from a place for a certain amount of time. Geographic restrictions are common in things like restraining orders, any sorts of minor crimes, illegal. What's happened recently is a significant expansion of them in 2024 under what they're calling the Safe and Sound program. I apologize I didn't submit this, but I will give it to your clerks. This is what they're showing to individuals who are charged with misdemeanors, petty misdemeanors, and sometimes citations. They want individuals to stay away from the entire west side of Oahu for crimes they have not yet been convicted of. In doing basic legal research, we have seen that this is a clear violation of the United States Constitution and the state constitution since the 1800s. There's further expansions of the protections for Native Hawaiians in terms of access and gathering rights and their ability to get onto unpurposed or undeveloped lands. We are coming to the legislature because it's been difficult to get these cases completed and get them to the appellate process. We believe that without your intervention, these things will continue. And I've only got a few more minutes, but a few more seconds. We actually figured out our own data. So they asked for it 109 times and we're only granted it 26 times. The courts agree with this. That was after 2 months of data. We hope you pass this bill. Thank you.
Thank you very much. Next up is Danielle Hugo for Department of Prosecuting Attorney for Honolulu. Or someone else or somebody else. Good morning.
Good morning, Chair Rhodes,
members of the committee. My name is Christine Denton. I'm special counsel to the prosecuting attorney, and we stand in on our testimony in opposition. However, I would like to correct something. The inception of the Safe and Sound program on the West Sides started November 1st to 2024 in response to community issues that they brought up to us and to the Honolulu Police Department. Since that time, we have had 96 cases. Only 4 of those cases were there a geographical restriction granted, and one of those was already terminated. Our directive to our employees is that we are not asking for geographical restrictions in that area unless it's extraordinary. For example, I can't talk about any specific cases, but there is a case where there is a fire set, and we don't want the person to go back and set more fires. The issue, the reason why we did that is because we recognize that people live and work and get treatment and have family and have things that they need to do in the West Side. So that's our testimony.
Thank you. Next up is Frank Schultz in opposition, John Deutschman in opposition. That's everybody who signed up on HB 892. Would anyone else like to testify on HB 892? Seeing none, members' questions? Okay, seeing none, we'll go ahead and move on. Next up is HB 994 relating to the offense of promoting pornography for minors. This authorizes the information charging for that offense. First on HB 994 is Albert Cook, Deputy Attorney General. Good morning.
Good morning, Chair, members of the committee, Deputy Attorney General Mark Tom, standing in for Deputy Attorney General Albert Cook. First, the department is in strong support of House Bill 994 HD1. We thank the committee for hearing this measure. This bill will essentially enhance the effectiveness of Act 244 from last year that the legislature passed that addressed the offense of promoting pornography for minors. By allowing, this bill will essentially allow for charging those defendants by written information to ensure that the defendants are held accountable for sometimes very large scale operations. We'll be here for any questions. Thank you.
Thank you. Next up is Yasmin Shaney for Hawaii State Commission on the Status of Women. In support, Daniel Hugo for Department of Prosecuting Attorney, City and County. Morning again.
Good morning, Chair Rhodes and Senator Sam Buenaventura. Daniel Hugo for the Honolulu Prosecutor's Office, and we're in strong support of this bill. This essentially will be most useful in cases where there's a sting operation in which the defendant believes that they're communicating with a minor and they send pornography during that time. The alternative is that we would have to take cases in which there are exclusively officer witnesses to grand jury, and that uses very limited grand jury spots that we would prefer to be reserved for victims of sexual offenses, actual live victims. Whereas when it's just police officers, typically the information charging process is sufficient. I'm available for questions. Thank you.
Thank you. Next is Frank Schultz in support, Tara Carlin in support. And that's it on those who signed up. Anybody else like to testify on HB 994 or 994? Seeing none, members, question. Seeing none, ready to vote if you guys are. Okay,
I got majority caucus too.
Okay, first up on the back to the top of the agenda, which is HB 126. We did post a proposed SD1. This is on civil asset forfeiture. The recommendation is to go ahead and accept the proposed SD1. This would make it so there has to be, among other things, it would make so you have to be, somebody has to be convicted of something before you can forfeit your property. You can still seize it, but you couldn't forfeit it. And then in addition to the SD1, we'd like to add an additional requirement, add additional reporting requirements on the seized property and the forfeited property. So both would have reporting requirements. Questions or concerns? Yeah.
I don't want an amendment now, but in the event that it goes to conference, and I think it will, would you consider an amendment to create a special fund for all assets forfeited so that those so we remove the profit incentive and the funds be used to pay for court-appointed fees.
Yeah, well, I'd be happy to consider it. Right now, the SD1 says it just goes to the general fund.
I understand.
Okay, we
But
will
you consider
I will
that,
certainly consider it.
Okay.
Other concerns? If not, Senator Chang.
Chair's recommendation for House Bill 126 HD1 is to pass with amendments. Chair Rhodes.
Aye.
Vice Chair Gabbard is excused. Senator Chang, aye. Senator San Buenaventura.
aye.
Senator Wah is excused. The recommendation is adopted.
Thank you very much. Next up is HB 280. This permanently establishes and appropriates funds for the Community Outreach Court as a division of the District Court of the First Circuit. Recommendation is to accept the Attorney General's recommendation, so we'll remove the Attorney General or Deputy Attorney General from the definition of a prosecuting attorney or deputy prosecuting attorney, and we'll remove the appropriation to the Attorney General, and also we'll put a different effective date on of April 23, 2057. Questions or concerns? If not, Senator Chang.
For HB 280 HD3, Chair's recommendation is to pass with amendments, noting the excusals of Senators Gabbard and Wah. Of the members present, are there any objections or reservations? Seeing none, the recommendation is adopted.
Thank you. Next up is HB 370. This increases the amount of partial public campaign financing available for all elective offices. The recommendation is to pass with amendments. So largely we'll go back to the version of the SB 345 that we passed out a few weeks ago. We'll amend HRS 11423D to modify the voluntary expenditure limits multiplied by the number of voters in the last preceding general election registered to vote in each representative district as follows: $3 for the governor, $1.68 for lieutenant governor, $2.40 for mayor, $1.68 for state senator, state rep, county council member, and prosecuting attorney, and 24 cents for all others. We'll insert the public funding amount of 67% for all the blanked out percentages and HRS 11425A. Accordingly, we'll substitute a single uniform provision setting the max amount of public funds available at 67% for all qualifying offices in place of the bill's current revision of that section. In line with that change, we'll repeal subsections B through D as they currently exist in the statute. We'll limit the maximum amount of public funds available in 11425A so that the candidate shall not receive any public funds when combined with the candidate's qualifying contributions. They are in excess of the expenditure limit, and will revert the qualifying contribution threshold for Office of Hawaiian Affairs offices in HRS 11491A back to the current statutory amount of $1,500, and we'll insert the requested appropriation language of $16 million in the committee report. That's it. Questions or concerns? If not, Senator Chang.
Thank you. Chair's recommendation for HB 370 HD2 is to pass with amendments. Chair Rhodes.
Aye.
Vice Chair Gabbard is excused. Senator Chang, aye. Senator San Buenaventura.
Aye.
Senator Wah.
Sorry. Partial public finance.
Public financing.
Yeah, I'll go aye on that.
Okay.
Okay, 4 ayes, recommendation is adopted.
Next up is HB 371. This is also related to campaign contributions. This prohibits state or county grantees and officers and immediate family members of state or county contractors or grantees from contributing to candidates or non-candidate committees. Recommendation on this one is to pass with some amendments. Find them. We'd like to modify the new subsection F to provide that new subsections B through D do not prohibit the establishment or administration of or solicitation of contributions to any non-candidate by committee by a person other than the state or county grantee or the owners, officers, and immediate family members of the state or county contractor. I'd like to replace new subsection 8. Oh, sorry. I'll read it again, not the owners. We'd like to modify new subsection F to provide that new subsections B through D do not prohibit the establishment of administration of or solicitation of contributions to any non-candidate committee by a person other than the state or county grantee or officers and immediate family members. I'd like to replace new subsection H with language adapted from subsection F of SB 809 SD1, providing that at the time of the execution of a contract subject to this section for for $100,000 or more for goods or services, or $250,000 or more for construction. The contractor or grantee shall provide to the office executing the contract a list of names for any officers and adult family members. So we're excluding the lower end ones, which is the concern raised by the State Procurement Office. The office shall then make the reported info available to CSC electronically for compliance purposes, and the CSC shall make any info available to candidates and non-candidate committees on a password protected section of the CSC's website. Also, SMA text, and I think there's a bad date on it already. Yes, so we'll leave the bad date. Questions or concerns? If not, Senator Chang.
Chair's recommendation for HB 370 is to pass with amendments, noting the excusal of Vice Chair Gabbard. Of the members present, are there any objections or reservations?
370,
371.
370, yeah, he's,
I'm sorry, 371.
371, HB 371.
okay. So with reservations, same concerns I had regarding the family members, state, First Amendment rights.
Okay, noting reservations for Senator San Buenaventura. Are there any other reservations or objections? Seeing none, the recommendation is adopted.
Okay, thank you. Next up is HB 413. This clarifies administrative oversight of statutory restrictions relating to prohibited lobbyist contributions, clarifies that the regular or special sessions in which lobbyist contributions are prohibited are periods during which both houses of the legislature are in session. We'd like to just make basically a technical amendment. We'd like to revise page 4, line 10 to 11 to read the executive director of the Campaign Spending Commission, which I forget what the effective date was.
Didn't say the executive director.
Oh, I'm sorry. So it didn't say what there's a reference to the executive director. It doesn't say to what executive director. That's it. Questions or concerns? So amendments with technical amendments. Seeing none, Senator Chang.
For HB 413, Chair's recommendation is to pass with amendments. Of the members present, are there any objections or reservations? Seeing none, the recommendation is adopted.
Thank you. Next up is HB 892. This establishes limitations on geographical restrictions provided as a condition of probation. I'm going to defer this one indefinitely. There's some conceptual problems with it in terms of what the right line between is. And I don't know if the smaller restrictions contained in this bill, what's the conceptual difference between that and the larger ones that we currently have? And in addition, judges are under no obligation to grant these, so they can say no anytime they want to. So I'm going to defer that one. That brings us to HB 994, authorizes the offense of promoting pornography for minors to be instituted by written information. Recommendation here is to pass as is. Questions or concerns? If not, Senator Chang.
For HB 994, Chair's recommendation is to pass unamended. Of the members present, are there any objections or reservations? Seeing none, the recommendation is adopted.
Okay, thank you, members. We do have a 10 o'clock agenda, which will be very brief. It's deferred from Tuesday, March 18. This is HB 111, authorizes civil claims to be made against a person, business owner or business operator that profits from sexual exploitation or sex trafficking. We're going to defer it another week to work on language. That would be March 25 on Tuesday, March 25, 10 a.m. in this room 016. That concludes our business. Thanks for being here.